There is a rule in Ohio courts that says a judge cannot silence anyone without holding a hearing first. 2 weeks ago, that rule was broken. Nobody rang a bell. Nobody sent out a warning. It happened quietly on a docket sheet in a small county courthouse. And now the largest newspaper in Ohio is standing in front of the state's highest court asking a very simple question. Did the judge in the Siders case follow her own rules? I want to tell you what just happened, because it matters more than most of the noise you have been hearing. Sit down with me for a few minutes. I am going to walk you through this the way I would explain it to my own mother at the kitchen table. Slow, clear, nothing fancy, because you deserve to understand this fight before the news moves on to something new. The paper is called the Columbus Dispatch. It has been printing news in Ohio for over 150 years. That means it has seen a lot. It has covered wars and elections and courtrooms and quiet scandals in small towns nobody else pays attention to. So when the Columbus Dispatch decides to sue the Ohio Supreme Court, you should pay attention, because papers that old do not pick fights they think they will lose. Here is what they are fighting about. Back on July 14th, a judge named Featherolf Rogers signed a gag order in the Siders case. That order silenced a group of people who were connected to Gary Siders Jr., one of the defendants. The Dispatch did not like it. They said it was too broad. They said the public had a right to know what was happening. So they filed a lawsuit against the sealed search warrants and against the gag order itself. They walked it all the way up to the Ohio Supreme Court. That fight was already in motion. Fine. That is old news. But now listen carefully, because this is the piece that is fresh. On July 23rd, that same judge signed a second gag order, this one for Christina Siders. And over the last 48 hours, lawyers reading the paperwork noticed something strange, something that made them stop and read it twice. Between the day the second gag order was requested, July 16th, and the day it was signed, July 23rd, there was no hearing. No hearing. Let me say that again because I want it to sink in. In Ohio, when a judge is asked to silence someone, the rule says a hearing has to be held first. That hearing gives the other side, usually the press, a chance to argue. It gives the public a chance to weigh in. It gives the judge a chance to hear both sides before she makes a decision. That is the rule. But between July 16th and July 23rd, the Vinton County Court docket shows nothing. No hearing scheduled, no hearing held. Just a request on one date and an order on another. In between, silence. That is what the Columbus Dispatch is now pointing at. They are saying, look, if you have a rule that says you cannot silence people without a hearing, and then you silence people without a hearing, that is not a small thing. That is the rule bending in the middle. And if a small county judge can bend it once, she can bend it again. And so can every other judge in Ohio, which is why this fight matters, not just for the Siders case, for every case that ever comes after it. Now, I want to be fair here, because I do not want you to walk away thinking the judge is a bad person or that she was trying to hide something. Judges are human. They make mistakes. Sometimes they cut corners because a case is moving fast. Sometimes they think they have the paperwork to justify skipping a step. And the judge in this case may have good reasons that will come out later. I do not know. Neither does the Dispatch. That is why they are asking a higher court to look at it. But here's what I want you to feel in your chest for a minute. We live in a country where the newspaper can sue the court. Think about that. In a lot of places in the world, if a newspaper sued a court, the newspaper would be shut down by morning. Reporters would disappear, presses would burn. That is not a joke. That is real. That is how most of history has worked. But in Ohio and in the United States, a newspaper can walk into the highest court in the state and say, we think you got it wrong, and the court has to listen. That is not a small thing. That is a miracle we forget about most days. So even if you think the Dispatch is going to lose this fight, the fact that they are even allowed to have it is something to be grateful for. Now let me explain the two rules that are crashing into each other, because this is the beating heart of the whole case. The first rule is called the First Amendment. It says the press is allowed to report on what the government is doing, including the courts, including judges, including cases like the Siders case. The First Amendment is why you can read a newspaper story about a criminal trial. It is why you can turn on the television and hear a reporter explain what happened in court that day. The second rule is called the Sixth Amendment. It says every person accused of a crime is allowed to have a fair trial. That means an unbiased jury. That means 12 people who have not already made up their minds before the trial starts. And that is where things get complicated. Because if the press reports too much, too loud, too early, it can poison the jury pool. It can make it impossible to find 12 people who have not already heard about the case. Both of these rules matter. Both are protected by the Constitution. Both come from the same founding fathers at the same time on the same piece of paper. So when they crash into each other, someone has to decide which one wins. That is what the Ohio Supreme Court has to figure out. Do they side with the First Amendment and say the press can report on what the judge is doing? Or do they side with the Sixth Amendment and say the judge was right to protect the future jury? There is no easy answer. Anyone who tells you there is not being honest with you. But there is a middle path, and that middle path is called procedure. Procedure is just a fancy word for following the rules. It means if you are going to silence people, you have to hold a hearing first. Not because the hearing is going to change the outcome, but because the hearing is proof that you thought about it carefully. Proof that you gave the other side a chance to speak. Procedure is what protects everyone. Both the accused and the press and the public. When procedure is skipped, everyone loses trust. Everyone starts to wonder what else was skipped. That is why this lawsuit is not really about a piece of paper. It is about trust in the system. It is about whether the public can look at a criminal case and say, yes, they did it the right way. Even if we did not like the outcome, we can live with it because they did it the right way. If the docket is missing a hearing, that trust starts to crack. Now let me give you a picture in your head. Picture a small courthouse in a small Ohio town. Maybe you have seen one. Brick building, steps out front, American flag, old wooden doors, inside a judge who has been on the bench for years. She knows every lawyer in town. She knows the sheriff. She probably knows the families involved in half the cases she hears. That is what a small county court is. Now picture a big newspaper in Columbus. Reporters in a newsroom, editors on the phone, lawyers on retainer. They see themselves as the watchdog. They see themselves as the last line of defense for a public that cannot be in the courtroom every day. Those two worlds do not usually talk to each other. They live in different Ohio's. The small county courthouse rarely hears from the big Columbus paper. And when they do, it usually means something has gone wrong. That is what this lawsuit is. Two Ohio's meeting in the state's highest court, arguing about the rules. And I have to tell you, watching this from the outside, it is one of the most American things I have ever seen. A newspaper suing a court. In a courtroom, using the same rules the court is accused of breaking. That is how a democracy is supposed to work. Messy, slow, public, loud. Now let me tell you what happens next. The Ohio Supreme Court will look at the paperwork. They will read the docket. They will see the gap between July 16th and July 23rd. They will read the July 23rd order itself. And then they will decide one of three things. Option one, they can side with the dispatch. They can say, yes, a hearing was required and no hearing was held, so the gag order has to be thrown out. If that happens, the entire silence around the Siders case cracks open in a single ruling. Every lawyer, every witness, every expert can talk again. The gate lifts. Option two, they can side with the judge. They can say no. In a case like this one, with children involved and with sensitive evidence, the judge had the right to skip the hearing to protect the jury pool. If that happens, the gag order stands. The silence continues. The trial moves forward behind the curtain. Option three, they can send it back down. They can say, we will not rule on this yet. Go back to the trial court, hold the missing hearing, and then come back to us if you still have a problem. That is the most likely outcome. Courts hate to overturn each other unless they have to. But no matter which one happens, this weekend is when the fight started. This is the moment you should remember, because the Siders trial has not started yet. The grand jury has not even met yet. And already, before a single witness has taken the stand, there is a trial about the trial. There is a fight about whether the fight will be fair. That is what I want you to hold on to tonight. The Siders trial has not started. The trial about the Siders trial already has. If you have followed this case from the beginning, you already know the size of it. 16 children, multiple defendants, a house full of things nobody should have to see. But the story is no longer only about that house. It is about how the courts handle what happened in that house. It is about whether the paperwork can keep up with the horror. It is about whether a judge in a small county can silence a big paper without following her own rules. That is a story worth watching, even for those of us who thought we had heard enough about this case already. Before you go, one last thing. If the Ohio Supreme Court hears this lawsuit and if they rule for the dispatch, we might see the whole legal structure of the Siders case shift in a single afternoon. Gag orders lifted, search warrants unsealed, names named. That could happen in the next few weeks. It could happen sooner. So keep your eyes open, keep reading, keep asking questions. Because the public did not put itself into this fight. A newspaper did. And a newspaper is only strong when the people reading it stay awake. Stay awake. Please stay awake with me. Because this case, the Siders case, is one of those cases that decides more than a verdict. It decides what kind of courts we want in Ohio, and what kind of press we want, and what kind of country we want to hand down to whoever comes after us. 12 children came out of that house one way, 4 more came out another way. All 16 came out alive. And what we do with their case now, in these paper battles and hearing gaps, is what we are teaching every child in America about whether the system can be trusted. Let us try to make it worth their trust. I will see you in the next one. Keep your family close. Keep your neighbors close. And if you know somebody who covers a courthouse for a living, tell them thank you, even the small ones, because they are the reason we know any of this at all. I want to close with one small thought. The Columbus Dispatch did not have to file this lawsuit. It costs money. It costs time. It costs relationships with judges the paper will have to work with again long after the Siders case is over. But they filed it anyway, because a paper that has been printing news in Ohio for over 150 years knows something the rest of us forget. Rules only work when someone is willing to fight for them out loud. That is what is happening this weekend, a fight for the rules, not a fight for a verdict. A fight for whether the verdict, when it comes, was reached the right way. Watch it closely, because whichever way the Ohio Supreme Court rules in the next few weeks, that ruling is going to shape how every gag order in this state is written for a long, long time to come. That includes cases you have not heard of yet. That includes cases involving your neighbors. That includes one day maybe a case involving somebody you love. The rules matter, the paperwork matters, and the small county docket that skipped a hearing between July 16th and July 23rd is going to be the reason a much bigger courtroom in Columbus has to decide what silence is worth. Stay with me. I will keep you posted.